Great state of Florida and this honorable court.
Thank you. You may be seated. Good morning and welcome to the First District Court of Appeal. We have one argument on our docket this morning. Case number 25-990, Purple Pride versus Larry Burgess. Mr. Rogner, when you're ready.
I am. I thought I had it high enough. Mr. Chief Judge, and may it please the court. My name is Bill Rogner. I represent the employer and the carrier in this appeal. I'd like to reserve 3 minutes of my time for rebuttal. Why are we here? Well, in the claimant's words at the trial, it's for me to go on vacation back home. And home, of course, is in New York. And the question is, who pays for the expenses related to this New York trip? We assert the case turns on medical necessity, which implicates two statutes. 440.13.2a says the employer shall furnish medically necessary care and attendance. And 440.13.1k says medically necessary means any medical service or supply used to identify or treat an injury. Now, the Montgomery Ward case cited in the brief 1995 case from this court, the court said, medical necessity constitutes the general defining term under which all compensable benefits under Section 440.13 must fall. So, we assert that this case is controlled by a factual finding. And the factual finding at page 33 in the record from the order appealed, there was no cross appeal, is that I find the trip to New York is not medically necessary. And that is the key to the case. We concede, and we agree, that if the purpose of this trip was for him to receive medical treatment that was only available in New York, we would be responsible for all costs without limitation. But this trip is personal, and to the extent the trip involves expenses above and beyond what we normally pay, the claimant is responsible. You've addressed this in your cases, and you've said transportation other than transportation to and from medical appointments is compensated through indemnity benefits rather than medical benefits. And that's the Timothy Bowser case, the Marlowe case, the Dade County versus Greer case. So the statute...
So what do we do in other situations where a claimant has needs that requires maybe attendant care and equipment, but they're snowbirds, they live in two places, or they operate out of two places. Does medically, and if these things are medically necessary, do those things need to get picked up in both places?
Well, the things are medically necessary, but the travel between those two places is not medically necessary. And there's not a single case, well, at least not a case that I've found, that's ever been decided by this court or by the Florida Supreme Court that says we are obligated to provide travel between two places unless the purpose of the travel is to receive medical care. And Your Honor, this is
how is this case different than a relocation, a permanent relocation?
Well, I think it's substantially different than a permanent relocation. I mean, he's going to visit family. What if he wanted to visit family every month or every quarter or every week for that matter? What if family, instead of being in New York, was in Hawaii or Haiti or Hanoi? Where's the limit? What test are you going to create? Because up until now, the test has been whether the purpose of the trip was medically necessary. Then we are responsible for all expenses. And I submit that we would not be responsible for the travel expenses between Florida and Maine if the claimant had two homes. And I don't have a single case that ever says otherwise. And the only cases we have are the ones that say we are not responsible for travel, whether it's the actual mode of transportation or, most commonly, it's whether we have to provide either a driver or pay an attendant, including a family member, to be the driver of the van. In this case, they propose that it's these nurses. These nurses are going to moonlight as van drivers. But in the Timothy Bowser construction case, the Marlowe case, the Dade County versus Greer case, those all involved an injured worker just like this one that was completely incapable of transporting himself from one place to another. And while Sympathy lies with that person. The question is whether the statute provides compensation for that. And in each case, they said no. For outings, for socialization events, to travel to stores, for various and sundry purposes, to travel to his mother's house, to travel to the store, to take a trip to the father's funeral, where the court expressed sympathy, as I do, for the injured worker's plight. But they said, look, workers' compensation only covers what it covers. The money portion, you get 2/3 of your wages, and there's nothing anyone can do about it if you don't make enough money from 2/3 of your wages to pay your bills.
So your focus in this appeal is with the travel part of the JCC's order, not the equipment part, which is also being duplicated because of travel, but that's,
No,
that works?
I'm challenging, I've challenged all of it, Judge. So here's the way I look at it. He already has a commode chair, he already has a shower chair, he already has a Hoyer lift, okay? They want us to rent another Hoyer lift, they want us to rent a commode chair, and they want us to rent a shower chair for the purpose of him taking a vacation to New York, okay?
So is the rule you just get one? One of each
You
class
get-
of equipment? Or if you live in two places, you just get one?
Well, if
Or
you
how
li-
does this work?
Well, if he lived in New York and he lived in Florida, perhaps that would be a different situation. But Judge, what we're talking about here is a vacation, okay? I just got a petition for benefits in another case demanding that we put 3 nurses and a Hoyer lift on a Royal Caribbean cruise based on this order, okay? So when I bring a case up here like this, I know that the party's interests are paramount. And I certainly have concern and sympathy for Mr. Burgess, okay? And obviously my client's rights are implicated, and it's important to my client as well. But what is often more important is what happens after you decide the case. That, to me, as the appellate court, and really for us, the last court, this is the end. We don't get to the Supreme Court very often.
And sure, certainly there are some limiting principle concerns here, but we'll address those to Mr. Porcher.
Yeah.
I mean, about how far can all this go?
Right,
with
and so-
cruises and whatnot.
What test do you create? That's the question I have. Mr. Porcher proposes a reasonable life choice, reasonable life decision. It's a reasonable life decision. Well, I think it's a reasonable life decision to want to go on a cruise with your family. I do. I think it's a reasonable life decision to want to travel to Europe with your family.
Or Marlowe to go to the store and whatnot. I mean,
That's right. That's right. It's important. It's important. It's crucial that people have the ability to travel to their father's funeral. Yet the workers' compensation system doesn't compensate for that. It only covers what it covers. It's a limited recovery. You know, I mentioned the wages. I mean, in a PI case, you can get your lost wages. In a workers' compensation case, you can only get 2/3 of your lost wages. And the court has addressed these other issues by saying it's not that the claimant isn't compensated for these things, but he or she is compensated through the indemnity benefit, because the medical benefit covers only what is medically necessary. And even though if someone travels to their funeral, their father's funeral, it's necessary that they have an ambulance, the court says because the purpose of the trip is not to receive medical care, the employer is not responsible for its cost. And that goes all the way back to 1964 to the Florida Supreme Court case Mobley. And Mobley said, okay, we agree, Supreme Court says, we agree there's no coverage in the statute for anything related to travel. But the claimant is absolutely entitled to medical care, and if you can't get to the doctor, you can't get your medical care. So travel to and from the doctor is part and parcel of Section 440.13's benefits. We then get the statute from 77 to 93, right? From 77 to 93, it said travel expenses are reimbursed, but only to and from the doctor. Then it gets repealed in 93. It goes into effect January 1, 1994. My firm brings up the Sam's Club v. Bear case, and we say, well, the legislature must have intended something when they took away the travel reimbursement provision. It must have meant something because of our statutory construction rules that say it's presumed the legislature meant there to be a change of the law. And this court said, true, We think they probably meant that. But that does not change the Supreme Court's construction of 440.13 from 1964 in the Mobley case. And therefore, we hold that the claimant is entitled to travel expenses necessarily incurred in obtaining medical treatment, the end.
Can you just speak to, all right, how far is the claimant allowed to use his van, right? Because there seemed to be an argument that even the wear and tear on the van is an unnecessary cost on your client.
Okay, well, I may have, that may not have been my intent when I wrote those words in the brief. That may not have been the intent of what I'm saying. Here's how I'd like you to think about that, Judge Treadwell, okay? In many cases, in fact, most cases, we don't provide vans. The vans are provided in a lot of ways because it's more convenient and often cheaper for the carrier. The Kraft Dairy case I cite in the brief, it addresses exactly this issue. Claimant says, I want a van. I want a van. And the carrier says, no, we're going to provide you with a medical transportation service to get you to all of your medical appointments. And the judge says, no, it's better for the claimant, it's more convenient to the claimant to have the van. And this court reversed and said, there's no obligation to give them a van because there's no obligation to provide them with transportation generally. You're able to satisfy that requirement by providing a medical transportation service. Now, in this case, we happen to have provided this gentleman with a van, but what happens in the next case? What happens in the next case? Not Mr. Burgess's case. When you say a vacation trip is fine, you have to pay for it. Most of them don't have vans.
Before your time runs up, too, I want to hear you on the jurisdictional argument as well. Or if you're
The first argument.
If you're continuing to assert that.
Okay, and I did assert it, and I didn't go there immediately because I'm trying to get to the heart of the matter in my 15 minutes. But my point with argument one is that the judge can't do the three things he did. He doesn't have the jurisdiction to do it. He said you must authorize, you must provide, and you must pay claimant for these medical services. You can't do that because if the workers' compensation judge orders us to authorize all of this stuff, then he is deprived of jurisdiction to order us to pay for it. Because once authorization is established, payment is, the exclusive jurisdiction for payment lies with the department. It's a completely different process. The judge of compensation claims has no role. So while I think that the order is deficient on a jurisdictional ground because of these inconsistent orders, you can't order both. I still hope that you do reach the second argument, because if you do say, Mr. Rogner, you're right on argument one, we're going to reverse and remand, we're going to come back again, because we're still going to be dealing with this, the meat of the argument involving entitlement to the expenses relating to travel. And I'm going to reserve the rest of my time.
Thank you. Mr. Porcher? And Mr. Porcher, you're wanting to reserve time for your cross?
Sir, reply.
Okay.
2 minutes,
Okay.
please. To make things as clear as possible, Mr. Larry Burgess has agreed to pay for his personal transportation. He is providing his van that is titled in his name. He has agreed to pay the gas. He has agreed to pay his hotel and lodging, and he has agreed to provide his meals. Those would be his transportation costs as the term is ordinarily understood. Claimant is only requesting authorization and provision of medical services. It's an appellant's job to identify specifically the legal error that the JCC made in this case, not in a Royal Caribbean cruise case, not in the next case that comes down the pike. Here, the JCC said, the employer carrier does not dispute that attendant care and durable medical supplies is required 24/7. And so those are two numbers, but they can be collapsed into one concept, always. He requires attendant care always medically because of his spinal cord injury. And so the employer carrier has raised not a rule of law, but a series of catchphrases from disparate cases to try to construct a rule of law that doesn't exist. The text of the law is supreme. In what it says, it means, and what it doesn't say doesn't exist. So I start with this. Workers' compensation is only available for a natural person. Corporation can't get workers' compensation, someone who is not a person. The word person and personal injury has predications that pre-exist the legislature's enactment of that law. This is a person, and we have an understanding of what a person is because of our experience. It further provides that the employer carrier shall, in mandatory term, provide all reasonable medically necessary services, durable medical equipment, for the period for which it is required. It is a temporal trigger. It is a temporal limitation. It is a temporal limitation. So the question is Mr. Larry Burgess a person? Yes. For what duration does he require attendant care? For what duration? And when does he require the durable medical equipment? And the answer is always. It travels with him, just like his injury.
Is there no, limiting principle in terms of the activities that a claimant can undertake that may or may not increase his medical expenses?
In Judge Treadwell, and I think that's why we have judges, because territorial disputes agree. Off the top of my head, I can think of 4 or 5 limiting principles. The first is you would need an injury that legitimately requires, from the physician selected by the employer carrier or as determined by the judge, that requires 24/7 attendant care for all activities of life. That unto itself is a limitation that eliminates much of the whimsy that we've talked about. The next is you would need the physician's support and endorsement to take such a trip for many reasons. Patients should follow their doctor's advice. They should work with their patients.
But
So
R&R is sort of universally helpful for humankind, right? So I don't know how much of a limitation that is.
Well, I think it is very much of being a person, respite care, or just relaxation. But Mr. Burgess needs this care if he's watching a terrible television show, a very educational show, if he's sound asleep, if he's going to church, if he's going to the store, he needs it. And so he has agreed to provide his transportation. So the cases that he cites to, they're disparate facts. The question was, I want my medical mileage or I want ambulance transport. And the court correctly said, you don't get ambulance transport and you don't get mileage or gas reimbursement for doing things that aren't medical. But a hard stop must follow there. Nothing else logically follows because it is not a rule. It is a rule of inclusion. It is not a rule of exclusion that you can extrapolate from and create new rules lest you violate the text of the statute. So the text of the statute says, for the period for which it's required. That is a limitation unto itself. And Judge Treadwell, I didn't get to the others. Then you have to have an individual, and I want to stay away from the facts of this case that would make it look like I'm trying to, I'm doing a closing argument. But Mr. Burgess was injured at 25 years old. He's a resident of New York. It's now 7 years hence, and he has been roughly isolated for that period of time. He is stuck at his 25-year-old wages and then reduced by 1/3. So the next limiting factor is you better have the financial ability to do what it is you want to do so that you can pay for your transport proper. And the initial brief says the judge required the carrier to pay for all of his transportation expenses. And we would say the judge required the employer carrier to pay for none of his transportation expenses. His person, he is taking care of every expense. And that is not a cheap endeavor. That is something you have to save up for when you're getting 2/3 of your 25-year-old wages. So that is another limiting factor. The next limiting factor is this: the judges of compensation claims. They are precisely in place because all of the eventualities of being a person and living life ordinarily cannot be cataloged. They can't be taxonomized. And so judges have to take the facts, they hear what the doctor says, they understand if he's doing something that's a little, not something that would be reasonably approved, and most doctors and patients are going to oblige by that. So,
Are these limiting factors grounded in the text of Chapter 440? And if so, where would you point us?
well, the JCC approval is the judge is called on to adjudicate disputes between the parties. And I would say on supremacy of text, when you say person, you don't just mean the body habitus of a person. You mean I would suggest that what does it mean to be a natural person in the state of Florida under the Florida Constitution? So
how do you address their argument? I mean, the language you quoted us, for such period, follows the language medically necessary. And so how do you address their argument, but for this optional trip, these extra medical expenses aren't necessary?
But you've just said the magic word, the extra medical expenses. That if they are medical expenses, then they are not Mr. Burgess's personal transportation. So assume Mr. Burgess lives in Glasgow, Montana, 4.5 hours from the nearest city or probably medical provider. They would say, we don't have to provide benefits in Glasgow, Montana, because we have to send attendant care 8 hours traveling a day, and we would have to pay them. And the statute would say, that is what insurance companies do. That's why you collect premiums. We're not asking somebody on the street corner to provide this. We're asking the insurance company to do what it got into business to do. We don't care how the provider gets there, because you're given authority to do that, and we don't come in and check it as long as you deliver. So I'd like to give and I don't think their statement really contemplates the fact that 24/7 Mr. Burgess requires this care and this equipment. It is not isolated by text or statute to a geographical location, much less a geographical location of the carrier's choosing.
Mr. Porche, what role, if any, does 440-192 play in this? Because that provision does talk about resolving benefit disputes for specific travel costs. And in it, in 192G, it says all specific travel costs, and you have to include dates of travel, purpose of travel. And so by using purpose of travel, the legislature seems to be indicating that purpose of the travel does matter.
Sure.
So how do you reconcile that?
Oh,
with the state?
So 441.92 is a pleading requirement statute describing what a petition must have. It neither creates nor negates any substantive rights under the law, and this court has held that, and I will file a supplemental authority. It neither negates, but the same provision also says, or any other dispute that the judge is called upon to rule upon. So any legal dispute that the judge is called to rely upon, 441.92 does not create the right to travel. It does not destroy the right to travel, nor does it mediate it. It
does indicate that the legislature put in that purpose of travel does play some role when there's a dispute over travel costs.
Well, certainly we can agree it plays a part in what a pleading requirement might be, but the 441.92 deficiencies are addressed by a motion to dismiss, and failure to raise a specificity requirement within 30 days negates that as an issue. So I would suggest it could not be a substantive requirement that endures after those 30 days to mediate benefit entitlement, because then if we said that, I would like a wheelchair to go about my activities of daily living. If they don't move to dismiss that, I would highly suggest they could not come in and hijack the wheelchair if somebody wanted to go outside and get a breath of fresh air, go to the store, visit with friends, or just move about community and be a person. and saying, hey, 44192 says you have to tell us the purpose of your travel. I hope I answered your question.
Mr. Bourget, can you briefly talk about this constitutional challenge on cross-appeal?
Sure.
Is there an aspect of the JCC's order that you're actually cross-appealing, or is
So-
this more of a constitutional avoidance canon type argument?
The cross-appeal is plenary, and the reason is Mr. Burgess won on the standards that he understood to be controlling. He requires this attendance for all times, for every activity of his life, and he prevailed on that. The employer carrier is demanding that there are restrictions so mediated by their geographical limits that themselves have no limit. So you could fix someone to a closet. If Mr. Burgess loses, that means there's a standard that has not yet been announced, and I am raising the cross appeal to avoid a complete reversal so the case can go back down. His trip has been delayed for 2 years. He is, recovered enough to where for the first time he wants to face and address, and his family as someone who no longer walks. It's been delayed for 2 years. If it's a complete reversal, it's delayed forever, and we've geographically confined him essentially as a prisoner of the carrier's geographic limitations.
So is the constitutional challenge basically, if we interpret the statute a certain way, you want to reserve the right to a claim that our interpretation is unconstitutional?
I would like the opportunity to put on a record to address it either facially, or it couldn't be facial because we'd have to create a new standard, but at least as applied. Yes, Your Honor. And I see I've got into my reply time, and I thank you very much.
Thank you.
Judge Norby, you're exactly correct. Imagine this. Imagine if Mr. Burgess was able to drive and he chose to take this New York vacation and he submitted mileage to travel to New York and back. We would never pay it. No one would even suggest that we would pay it. Why? Because the purpose of the trip is not to receive medical care. And yes, he has said, I'll pay for my own gas and I'll pay for my own hotel rooms. What happens to the next claimant after you decide this case? And he's not agreed to pay for the enhanced overtime rates that we have to pay the nurses. He has not agreed to pay for the nurses' hotel rooms that we are being required to pay for. So his agreement or attempt to be reasonable or to participate in the cost of this trip is laudable, but it doesn't make any difference from a legal standpoint. Because what will happen, it's guaranteed, if you affirm this decision, then we're going to have other cases where the claimant's going to say, well, why would I volunteer to pay for the gas? I have the right to go visit my parents or my grandparents in whatever state, whatever country. And that's why this case is so important, because how you decide it is going to be really important moving forward as to what we face and what we have to deal with on both sides. Okay. As far as the cross appeal is concerned, I frankly did not understand the argument that was raised in the brief. There was no clear issue statement saying what was unconstitutional or how it was unconstitutional. And there's nothing new about what we're asking you to do. There are multiple cases that simply say, if the purpose of the trip is not to receive medical care, we are not responsible for its costs. This is no new standard. This has been in existence for decades, and I cited the multiple cases, holding that to be so. And if the court has no further questions, I'll take a seat. Thank you.
Mr. Wagner. Mr. Bourget?
Sure. Mr. Burgess does have the right to visit his family. He does have the right to live his life normally. He has agreed to pay for his transportation cost, every dime for transporting his person. The employer carrier has negated the judge's finding that the adjuster agreed and has no objection to providing attendant care, whether in Georgia, New York, et cetera, they just won't authorize it. Authorization is a predicate act of furnishing the care, and there is no danger because the job of this court is to decide the case before it. The job of the appellant is to identify the specific legal error. So as soon as the appellant says, well, it's not this case, well, this is a case where Mr. Burgess has agreed to pay his transportation expenses.
Mr. Porcher, I just
Yeah.
wanted to clarify with regard to your constitutional claim. When you filed your notice of cross-appeal in May of 2025, you said that the cross-appeal seeks to challenge Section 440.13. Did you ever file a notice of constitutional challenge and serve the Attorney General as required?
I did not. I did not. I'll happily do that if that's something that's required of me.
Okay.
They usually don't. But I'm sorry. I did not.
You may briefly conclude.
Okay, thank you very much. The text of the law is supreme. Natural persons are entitled to Medicare for the duration for which the medical care is required. Here it is 24/7. The judge was asked to determine whether this was appropriate, reasonable, and safe, and the answer was yes, and Mr. Burgess has agreed to pay for every dime of his personal travel expenses. Thank you.
Thank you, Mr. Shea. That's our only argument for today. We are adjourned.
All rise.